Hi guys, so in this lecture we will be discussing competence to refuse an insanity defense and other mental state defenses. The first question we need to discuss is when might a defendant need to be found competent of making these decisions? It starts at the hands of either the defense attorney, prosecution, or the court. They believe the defendant was insane at the time of their offense. However, the defendant does not want to use that in their defense. In a similar situation, a defendant's competency may also come to question if they object to use mitigation evidence, which is the evidence presented in favor of the defendant not getting the death penalty, or if a diminished capacity defense is being used. There are two approaches in regards to insanity defenses, split by two lines of cases. The first line is led by Whalum versus the United States. This case is followed less often, and the reasoning will speak for itself as I explain. So, this case required judges to practically force an insanity defense, even when denied by the defendant if said defendant was clearly mentally incapacitated. Judge Bazwan of this case basically wrote that someone who acted criminally due to their age or mental illness didn't commit a crime since they aren't mentally responsible for their acts. In other words, they may have physically committed a crime, but mentally they were not aware of their actions. So, in cases as such, if a defendant is attempting to reject an insanity defense, it's the judge's ethical responsibility to override their wishes, being that the person is technically morally blameless due to their condition, whether they were found competent or not. Frendake versus the United States takes an oppositional approach. Cases that follow Frendake, being the majority, require the follow through of a defendant's decision if the defendant is competent to make those decisions. If they understand the choices they are making, then they are capable of facing the consequences of said choices. So, if a defendant chooses to refuse an insanity defense and it results in them receiving the death penalty, then that was the decision they chose to make since they had the freedom to do so. The next slide is going to further explain the 5 reasons as to why someone would risk worse outcomes like the death penalty by denying an insanity defense. The first reason why a defendant may feel like they should refuse an insanity defense is because with it, they could be confined longer than if they were regularly convicted. This could simply be due to the length of their treatment. On that note, the second reason stems from the quality of treatment itself. Maybe the defendant believes they will receive better treatment in a prison as opposed to in a mental hospital. The third possibility is that the defendant doesn't want the label of being mentally ill. Reason number 4 suggests that the defendant risks losing their legal rights. The book used an example of losing the right to obtain a driver's license. Finally, the defendant might have intended for their crime to be a religious or political act, and receiving an insanity defense completely counteracts that. Now, rather than their crime being committed to make a stand for something they believe in, the crime was committed because they have a mental condition. This aligns with Dylan Roof in his case because he waived counsel to avoid an insanity defense in order to uphold credibility as a white supremacist and spread his beliefs. So in terms of evaluations now, within jurisdictions that follow the Whalum ideology, a defendant who doesn't want a mental state defense but imposition of that defense is allowed, receive an evaluation that is similar to that of a mental state at the time of the offense evaluation. Alternately, the Frendake style jurisdictions, the evaluation relates closely to the one required to assess a defendant's competency to proceed. So if a defendant is found competent to stand trial, then in turn, they are also competent to waive an insanity defense. So as I mentioned, the evaluation for Frendake style jurisdiction aligns with that required to evaluate one's competency to stand trial. However, they simply align and are not identical by any means. The decisions a defendant makes while undergoing trial are different from the decision of whether or not to assert a mental state defense. In these instances, it is important for an evaluator to be aware of the fact that the evaluee could be refusing this defense due to their denial of their mental disorder. In this case, the evaluation is taken to the next level, and an assessment of mental state at the time of the offense is also required to be explored. In addition to the possibility of denial, the defendant's level of understanding of alternate defenses, consequences, and success levels must be evaluated in order to ensure that the defendant's reasoning isn't being swayed due to the symptoms of their disorder. So, all in all, ultimately, it is up to the judge to decide if the defendant is competent or incompetent to make the decision to refuse an insanity defense. The supporting material I decided to include in my lecture is an article I found on Cronkite News that is titled Troubled Defendant Still Has a Right to Reject Insanity Plea. I found this article interesting, especially because it happens to discuss a case that is taking place in Arizona and also has support from a law professor at the University of Arizona. I'm not local, but I found it cool how this case is semi-local to those of you that are around ASU right now. However, this case is a little bit old too. I think it was in 2019. So anyway, this article talks about Jonathan Lee Reed's case where he claimed to be driven by demons to stab his cellmate to the point of causing serious bodily injury. This case is so incredibly relevant to everything we've discussed so far because the lawyer initially followed the guidelines set in place by the Whalum style jurisdiction, but that is now receiving backlash, which takes us to the Frendake style. At first, Reed's attorney disregarded his wish of not using an insanity defense and proceeded accordingly. In time, his conviction was reversed and a new trial was ordered, and an insanity plea isn't being used in respect to Reed's wishes. While Reed still was required to have an attorney represent him, the attorney was not allowed to decline his wishes of rejecting an insanity plea. You can read the entire article by clicking the link in the description box to learn more details about the case. It's a very short article, so I definitely suggest just giving it a quick read. I want you to now take a moment to reflect on what you have learned thus far and think about the answer to the following discussion question. Explain the division between the two approaches in regards to the insanity defense. Which approach should persuade the court by greater means? In other words, why might the Frendake view hold greater value than the Whalum view, or vice versa? These are my references. I used our textbook to find all of this information. And the second reference is the article I just briefly discussed to you guys. Thank you for listening to my lecture, and I hope I successfully explained this concept to you. And let me know if you have any questions or need any clarification on anything I may have said this entire time. Thank you, guys.